something like that, who went to OPA.
Okay. All right, then. I am going to appoint a private attorney to represent you, Mr. McMullen. I'm going to appoint Angel Runnels on her behalf. Mr. Van Buren, would you accept that appointment and waive any further reading and advising?
Yes, Your Honor.
And Mr. McFall?
Not opposed to a PR, Judge.
All right, Mr. McMullen, in your case then, I'm setting your bond at a personal recognizance bond. That PR bond is conditioned on your good behavior. You must stay in contact with your attorney, attend all of your court appearances. We'll enter a not guilty plea on your behalf and set then a 45-day preliminary hearing. Thank you.
Thank you.
Could I next see Wardell Williams, please? Mr. McFall, it looks to me like counts 1, 2, and 3 in the alternative, then counts 4, 5, and 6 separate, but in the alternative to one another?
Yes, Judge.
Okay. Mr. Williams, in criminal file 22-5188, you are charged in counts 1, 2, and 3 with 3 alternative counts of domestic abuse, simple assault. Domestic abuse, simple assault is a class 1 misdemeanor punishable by up to 1 year in jail and or a $2,000 fine. When I say that the charges are in the alternative, that means that the state could attempt to prove you guilty under 3 different subsections of the simple assault statute. But even if you're convicted of each of those, you could still only receive 1 penalty or 1 punishment. Simple assault is an enhanceable misdemeanor, meaning if convicted of simple assault 3 times in 10 years, the third can become a class 6 felony. Then in counts 4, 5, and 6, you are charged with 3 alternative counts of non-domestic simple assault. Again, simple assault is a class 1 misdemeanor punishable by up to 1 year in jail and or a $2,000 fine. Same explanation as far as alternative counts go. Even if convicted of each, you could still only face 1 penalty or 1 punishment. And again, simple assault is an enhanceable misdemeanor. Then in count 7, you're charged with resisting arrest, and count 8, obstructing a law enforcement officer, jailer, or firefighter. Each of those charges is a class 1 misdemeanor. Each is punishable by up to 1 year in jail and or a $2,000 fine. You understand all the charges that you're facing here and the maximum penalties, Mr. Williams?
Yes.
I do have your application, sir. Was the information you wrote down true and correct to the best of your knowledge?
Yes.
And that's your signature, Mr. Williams?
Yes.
I do find that you qualify, sir. I am appointing the Public Defender's Office to represent you.
We will accept that appointment, wait for the reading and advising.
Mr. McFall?
Judge, I'm not opposed to a PR requesting no contact. 2 alleged victims, Patricia Bone Shirt and Philomene Bone Shirt. Thank you.
Anything, Mr. Van Buren?
Do you live with either of those individuals, sir?
Pardon?
Do you live with either of those individuals?
Philomene, she moved in with me and my father when she got out of prison a few days ago.
Okay, do you need an order to retrieve your belongings from that address? Since you won't be able to have contact with her?
Shouldn't be there then, because that's, my father and I secured that place while she was in prison.
Okay.
Okay. All right, so Mr. Williams, in your case, I am going to release you on a personal recognizance bond. That PR bond is conditioned on your good behavior, must stay in contact with your attorney, attend all of your court appearances. I am ordering until further order from the court that you not have contact with either Philomene Bone Shirt or Patricia Bone Shirt. No contact means no contact in person, no telephone calls, no voicemails, emails, text messages, third-party contact or social media contact. I understand the difficult position that puts you in if they are or have been staying at your house. You can't have contact with them. If you can have your father figure out a way to ask them to leave, if it is your house or his house, you can certainly do that, but you cannot have contact with them until you have further order from the court. Do you understand?
Your Honor, my father, I'm his primary caregiver. He lost his ability to speak. He can't speak pretty well. Nobody take care of him but me.
Okay.
And we live there.
Well, and I'm not ordering that you can't be at the house. I'm just ordering that you can't have contact with her. So if she's there, you can't be there. You can you could ask to have law enforcement remove her if she doesn't have, if she's been asked to leave and doesn't have any right to stay there, but I'm not sure that that's gonna be successful, and you just need to make sure that you don't have contact with either of those people, because the court doesn't have any jurisdiction over them. We only have jurisdiction over you because you're charged with a crime, okay? I don't want you to get in trouble by having contact with them, so just make sure that you're steering clear of them. You can be at the house if they're not there, but you just need to make sure that you don't have contact with them,
Your
okay?
Honor, for 3 years, Patricia been homeless, and she just pop up at my house. I don't invite her. She just shows up, drunk, high, and when there's pretty much nothing I can do, even though it's my home. I'm a prisoner in my own home.
Well,
They
if
just take
this
over.
person shows up and you don't want them there, and you can call law enforcement and have them removed if it's your home.
Honor, I tried that. When they made these false claims against me, I told them I didn't want her there for the safety of my father. They said,
Well,
she can be there.
I'm hesitant to have you say anything about the facts of the case because I don't want you to hurt your case here, Mr. Williams. I need to be very clear. You can't have contact with either of those two people until further order from the court.
Yes, I understand that, but what I'm saying is, I don't have contact with them. She comes around my place because she's homeless and need a place to stay. And it's like, even if I say no, she will not leave.
Well, I suspect that if you called the police and said, this person is at my door and I have a no contact order and I'm trying to keep her away from me, I'm pretty confident they would make her leave at that point. Okay? Especially if you say, I'm trying to not violate a no contact order.
Yeah.
But that's the best advice I can give you, Mr. Williams. If you need assistance as far as getting people removed from a home, you might need to consult with an attorney. But I can't give you any legal advice as far as that goes, okay?
Yeah.
You should be released later on today then, Mr. Williams. Thank you.
Okay, thank you.
Could I have Harvey Whitehorse come up, please? Criminal file 22-5186. Mr. Whitehorse, you are charged with threatening a law enforcement officer, his or her family. Pardon me, that is a class 1 misdemeanor, punishable by up to 1 year in jail and or a $2,000 fine. You understand that charge and the maximum penalty?
Yes.
I have your application for an attorney. Was the information you wrote down true and correct to the best of your knowledge?
Yes, Your Honor.
And that's your signature, Mr. Whitehorse? Find that you qualify and appoint the public defender's office to represent you then.
And we will accept that appointment, wait for the reading and advising.
And state's position on bond.
No objection to a PR, Judge.
All right, Mr. Whitehorse, as the state is not objecting, I'm setting your bond at a personal recognizance bond. Your bond conditions are that you be on good behavior, stay in contact with your attorney, attend all of your court appearances. You're on probation, is that true?
Yes, Your Honor.
And comply with all aspects of your probation, do you understand?
Yes.
We'll enter a not guilty plea. We're gonna set your case then for pretrial and trial dates. You should get those dates before you're released.
All right.
Thank you.
Thank you.
Could I next see Michelle Rodriguez, please? Ms. Rodriguez, you are here in criminal file 22-5117, alternative counts of simple assault. Mr.
Yes, Judge.
In count 1, you are charged with 1 count of domestic abuse, aggravated assault. Aggravated assault is a class 3 felony, punishable by up to 15 years in prison and or a $30,000 fine. In counts 2, 3, and 4, you are charged with 3 alternative counts of domestic abuse, simple assault. Domestic abuse, simple assault is a class 1 misdemeanor, punishable by up to 1 year in jail and or a $2,000 fine. When I say that the charges are in the alternative, that means that the state could attempt to prove you guilty under 3 different subsections of the simple assault statute. But even if convicted of each, you can only face 1 penalty or 1 punishment. Simple assault is an enhanceable misdemeanor, meaning if convicted of simple assault 3 times in 10 years, the third could become a class 6 felony. Do you understand the charges that you're facing here and the maximum penalties, Ms. Rodriguez?
Yes, sir.
I do have your application. Was the information that you wrote down true and correct to the best of your knowledge?
Yes, sir.
And that's your signature on the bottom, is that right?
Yes, sir.
You do qualify. I am appointing the public defender's office to represent you.
And we will accept that appointment, wait for the reading and advising.
And Mr. McFall?
No objection to a PR, Judge, requesting no contact with Mackenzie Rodriguez. Thank you.
Anything, Mr. Van Buren?
No, Your Honor, these individuals do not live together.
All right, Ms. Rodriguez, as the state is not opposed, I will set your bond at a personal recognizance bond. That PR bond is conditioned on your good behavior. You must stay in contact with your attorney, attend all of your court appearances, and until further order from the court, cannot have contact with a Mackenzie Rodriguez. That means no contact in person, no telephone calls, no voicemails, emails, text messages, third-party contact, or social media contact. Do you understand all that?
Yes, sir.
We'll enter a not guilty plea. We will set a 15-day, or 45-day, preliminary hearing. We'll get you that hearing date then.
Thank you.
Thank you. All right, so the case where we need an interpreter, we have to use language line, so I've been holding off on that one till the end. Do you have top sheets for the others?
Yeah, which one?
Do we have Robert Gamble present?
Your Honor, he was uncooperative with coming today, but only had 2 charges that I believe were PR and a parole hold.
Okay.
We advised his parole agent, and I think we're gonna just write him PR bonds and give him
Okay,
dates.
so he's gonna be given a new date?
That's my understanding, sir.
Okay, how about Dalton Goodface?
He was cooperative for a little while, and then we had to remove him. He has, I believe, 1 charge that's holding him, and then a parole hold. I believe he, like the other gentleman, is trying to avoid going back to the prison.
Okay, well, we'll pass Mr. Goodface until tomorrow.
I did send a 48-hour review through for him.
Okay, I'll look at that before we recess here today.
Thank you, sir.
Do we have David Olson?
Yes, sir.
This is POA 228174, City of Sioux Falls versus David Olson. Mr. Olson, you are just on today's calendar for 1 ticket. It's a public consumption of alcohol ticket, which is a city ordinance violation punishable by the fine that's written on the ticket. You're here in custody because you failed to appear at your initial appearance back on June 7th when you missed that court date. A warrant was issued for your arrest, so that's why you're here on that today. Do you understand that charge and why you're here on it today, Mr. Olson?
Yes.
Did you want to have an attorney help you with that ticket?
I have a income tax coming within 30 days and I could pay it.
Well, if what you are interested in doing is pleading guilty, I actually, because of the amount of the fine, you can actually get credit for 1 day that you've been in jail. That'll actually pay off your fine. You also could plead not guilty and we could schedule it for a court trial if you preferred, but it's your option. I just want you to understand that you have enough credit now where you could pay off your fine if you wanted to plead guilty.
I'll plead guilty.
You'd like to plead guilty? Okay. The ticket was written for $107.50, which includes the court costs. I can give you credit for a day served. That's going to pay off your fine. And so that'll take care of this case.
Okay.
Okay?
Yeah.
All right. Thank you, Mr. Olson. Sean Schuster is next, please. Do we know what's happening here?
I want to.
Doesn't want an attorney?
Your Honor, the reason I don't want an attorney is because I have an attorney on some other stuff similar to this case, pretty much copycat. I've set up LSS, domestic violence, and marriage counseling through DSS. I did that this week, and I'm supposed to be there this week. So I wanted to plead guilty to this one.
Okay.
And then go forward with that. I got visitation with my kids through DSS. You met my wife earlier today, so I'm going to do that if I can.
Let me, let's do a couple of things. We're going out of order here quick, Mr. Schuster. So let's talk about how you want to handle the case, and then you're kind of making a sentencing argument. I don't want to cut you off, but I'll give you a chance to say anything you'd like to say if what you really want to do is plead guilty, but I just want to advise you of the charges here, okay? So in criminal file 225195, you are here on 2 counts of violation of a domestic abuse protection order, no contact order. Each count is a class 1 misdemeanor. Each is punishable by up to 1 year in jail and or a $2,000 fine. Violation of a protection order or no contact order is an enhanceable misdemeanor. That means that if convicted of that same offense 3 times within 10 years, the third could become a class 6 felony. And then you actually also have a traffic ticket, failure to register an acquired motor vehicle. It's a class 2 misdemeanor punishable by the fine written on the ticket. You missed your initial appearance a couple of weeks ago on that ticket, so that's why you're here in custody on it. Do you understand the charges and the maximum penalties, Mr. Schuster?
Yes.
Now, earlier you had said that you did not think you want to have an attorney. Is that still true?
Yes.
You don't want to have an attorney help you?
No.
Well, were you saying that because you already have Mr. Coyston representing you, or
What's that?
you already have Jason Coyston representing you on other matters?
Other matters, and I don't want one on this one. I just want to plead guilty and get it over with. I've already have stuff set up through the courts as far as the LSS and stuff like that. My assessment for domestic violence is this week. So I'm just gonna go ahead and plead guilty to this.
So you wish to plead guilty, Mr. Schuster? Are you certain that that's what you wish to do?
Yep.
Okay, Mr. McFall, if Mr. Schuster chooses to plead guilty, how would you propose to proceed?
Judge, I would ask for a cap of 45 days with more time suspended, and then any statutory requirements that would go along with that, and then open fines and conditions.
So you'd be asking for plea to 1 count?
Yes, Judge.
I don't know if I could speak with Mr. Schuster.
You certainly can if you'd like to.
Okay.
Mr. Schuster, why don't we have Mr. Van Buren just speak to you for 1 second here? I'm going to take a different case and I'll come back to you in just 1 moment. Do I have Richard Weisgaver? Is that how I pronounce your last name?
Yes, sir.
This is criminal file 225192. Mr. Weisgaver, you are charged with possession of a controlled drug or substance in Schedules 1 or 2, which is a Class 5 felony. It's punishable by up to 5 years in prison and or a $10,000 fine. You're also charged with entering or refusing to leave property after notice and with use or possession of drug paraphernalia. Each of those is a Class 2 misdemeanor. Each is punishable by up to 30 days in jail and or a $500 fine. So do you understand the charges and the maximum penalties, Mr. Weisgaver?
Yes, I understand the maximum, I understand the charges.
Would you like to have an attorney help you with these matters?
No, not one bit, sir.
Are you planning on representing yourself or hiring an attorney?
I guess I'll just represent myself.
All right, well, at some point in the, as this case goes along, a judge will strongly urge you to reconsider that position, but I'm not going to do that today. Obviously, it's your constitutional right to represent yourself, but as the case moves on and if you get close to a trial, you will hear from another judge or from me, depending, that it's a good idea to have an attorney represent you. But for today's purposes, if that's what you wish, that's fine. Mr. McFall's State have a position on bond?
Not opposed to a PR, Judge. I'm just requesting a no drugs condition.
All right, so Mr. Weisgaver, in your case, as the state is not opposing it, I am going to set your bond at a personal recognizance bond. Your bond conditions are that you be on good behavior, stay in contact with your attorney if one is later appointed, or if you hire one, that you make all of your court appearances, and that you not possess or consume any drugs without a valid prescription. You understand all that, Mr. Weisgaver?
Yes, sir.
We're going to enter a not guilty plea then. We'll set this matter for a 45-day preliminary hearing. I'll just remind you that because these are felony charges, or there is a felony charge, you just need to make sure that you are personally present at any court dates going forward. Okay?
Yes, sir.
All right. Thank you.
Thank you.
Anything different, Mr. Van Buren?
I think Mr. Schuster has agreed to, I guess, request counsel. We do have open files here already. Mr. Kleistman and Ms. Topol-Klein both have open files, so I don't know if we can just skip the application process or.
Okay. So, Mr. Schuster, after speaking with Mr. Van Buren, I'm told that you have reconsidered and that you might like to have an attorney help you with the case. Is that correct?
Yes, because we made agreements on this other case about the no contact. This wasn't even supposed to be in place.
Oh,
Or whatever.
yeah, thank you.
So, Mr. Schuster, I understand that you have a public defender on your other cases. Is your financial situation the same today as it was the last time that you applied for an attorney?
Yes.
Mr. Van Buren, if I appoint from the bench, is that going to cause a problem opening up the file in your office?
I don't think so.
Okay. Then I'll appoint the public defender's office to represent Mr. Schuster on criminal file 225195 as well. Would you accept that appointment, waive reading and advising?
Yes, Your Honor.
Mr. McFall, sounds like we're transitioning to a bond argument now.
Yes, Judge. I'm requesting $2,000 cash only, no contact with Prairie Schuster. A sequence of events leading up to this allegation. There's an alleged simple assault with the protected party June 3rd. Violation of protection order stems from that with the date of incident June 28th. Another alleged violation of protection order on July 11th. These are now allegations number 3 and 4 of violation of protection order. As far as the allegations here go, a third-party witness was able to see this individual aggressively yelling at Prairie Schuster at an intersection, trying to get her into a vehicle left the scene, and then later on August 1st, law enforcement found the two together in violation of that no contact order. I think it's pretty clear that he refuses to comply with bond conditions. As far as history goes, November of 2021, violation of protection order conviction. Prairie Schuster was the protected party in that matter, was sentenced in January of this year. October of 2021, had a simple assault domestic with Prairie Schuster as the alleged victim that was dismissed with a plea to an interference with emergency communications. And in 2021, had a simple assault domestic reduced to a disorderly conduct with Prairie Schuster as the alleged victim. Thank you.
Your Honor, I did not.
I appointed an attorney to represent you. Why don't you let Mr. Van Buren make an argument for you here, Mr. Schuster?
Your Honor, from reading the reports here, as Mr. McFall indicated, the reporting party was not the alleged victim, Ms. Schuster. The reporting party also made clear that there was no assault that took place. It was just a verbal argument. And the alleged victim, when interviewed by police, confirmed that as well. I think most crucially, Prairie Schuster said that she did not want the no contact order to be in place. I think her exact words were that she just wants people to leave her and her husband alone. I guess we know from what happened earlier today that Ms. Schuster also had an active warrant out, I believe, from about the time this incident allegedly occurred. So that probably could explain why she did not, I guess, want to appear in court to request that the no contact order be dismissed. Now that her warrant is cleared up and she will be out of custody without anything to prevent her from being in court, I'm hopeful that she will go through the proper channels to request that that no contact order be dismissed so that this wouldn't be a problem going forward. In the meantime, I think Mr. Schuster certainly has gotten the message that it doesn't matter whether Prairie wants contact with him. That's not going to be legal until the court actually, I guess, dismisses that no contact order.
It was part of a plea agreement already.
Okay.
It was part of.
Well, we don't.
It was part of.
He says that it was apparently part of the plea agreement that perhaps was not official yet, but I have full confidence that that'll be taken care of shortly. So based on that, Your Honor, we would request a PR bond here. Again, he understands that even though it's part of a plea agreement, it's not official yet. So we would ask that a PR bond be granted here. Again, Sean understands at this point how to go about getting this taken care of. He'll work with Mr. Poiston to get the no contact dismissed. Thank you. And these are all our misdemeanors again, so we request a PR bond.
Mr. Schuster had pled guilty to simple assault domestic and violation of a protection order. I think if I understand what he is saying correctly, it's that he is alleging that no contact orders were supposed to come to a conclusion with the pleas, but he hasn't been sentenced yet, and Judge Robertson did not modify the bond conditions, so they are still in effect.
I will live by them.
Your Honor, if I could just mention, I think that there's an LSS appointment coming up. That's probably the reason that the sentencing hasn't been done yet. So we could expedite the conclusion of all these cases with him being out of custody and going to LSS for that appointment.
I'll live with the PR. I won't contact her if that's what they want. I never have. I thought it was over with.
When is your LSS appointment, Mr. Schuster?
This week.
This week when?
I think Friday.
Maybe Friday or Friday?
Friday, I'm sure. Well, what's the date today, Your Honor?
Today is the 2nd.
Yes, it would be Friday then.
It's on the 5th?
Yes. We also start marriage counseling,
Well, don't
but we
say.
separate.
Okay.
I'll tell you what, Mr. Schuster, there's one way I'm willing to release you on a PR bond. I'm going to put you on UAs. Can you do UAs? Can you succeed at that?
Amen, Your Honor. I'll do it. I will.
Yeah?
Yeah, me and my wife kind of want that anyway, as far as like.
Well, your wife is on them as of today, so if I put you on them, you'll do them?
Yes, sir.
Because if you don't, I'm gonna hold you in jail.
I'll go.
All right, in this case then, I certainly understand why the state is asking for the bond. I probably should put it in place, but I'm gonna give you a chance here, Mr. Schuster, given, I guess I can understand some of the confusion, given that you're awaiting sentencing. But you are gonna have a no contact order because it's in place in the other case anyway. If Judge Robertson ultimately lifts it, I'll probably lift it in this case as well, but I just don't want you to be confused and keep getting arrested for it. So there's gonna be one in place, you understand?
Yes, sir.
All right, in this case, PR bond, good behavior, stay in contact with your attorney, attend all of your court appearances, no drugs without a valid prescription, 24/7 with UAs twice per week, or the drug patch, you can choose. No contact until further order from the court with Prairie Schuster. That means no contact in person, no telephone calls, voicemails, emails, text messages, third-party contact, or social media contact. I need to have you review and sign that form.
How about property?
Now, here's what, actually, I'm adding one other bond condition as well. That is that you attend your LSS evaluation on Friday. I'm gonna give you a pretrial conference next week. I'm gonna check to make sure that you attended your appointment on Friday. If you did, then we'll be good. If you didn't, then the state very well may file a motion to revoke your bond.
Okay.
Because really the only reason I'm letting you out is because I think it's in everybody's interest, and especially yours and your wife's, to have you attend that appointment.
Okay.
But if you're not gonna do that, then you might as well be in jail, yeah?
Okay.
All right.
If property, can I get something for property too?
Yep,
See-
Public Defender's Office will drop an order for me and I'll sign that. What address do you need to be able to go to?
It's, the Bishop Dudley house, we both stay there,
Okay,
but we're gonna have to come up with some kind of arrangement.
I understand. But they'll draw up an order for personal belongings to allow you to go to the bishop to get your things. And then I'll see you next week.
All right, thanks, sir.
And then just pass that along for now. I'm sorry. Should have addressed that.
That's the 101 North Indiana.
All right, and then we've got to do we know if Mr. Burgess is planning on coming today?
They're getting the three gentlemen right now. As far as I know, they're all coming. I can do a little checking if you'd like.
Okay. Now, we were gonna try and kind of do them one by one. Is that still what we're gonna hope to do? Or not really? Seamus said that we might not really have the option of doing that, so.
I believe all three of them are here, Your Honor.
Okay, well, I'm gonna do this language line case first, so.
Sure.
Well, we heard it there, so we may see him or we may not, but at least you heard him mentioned.
Your Honor, just so the court's information, I have Mr. Rodriguez and Mr. Burgess. Mr. Grunwald we're still attempting to get him down here, but he's not being very cooperative.
Okay.
Thank you for calling Certified Languages. Hi, this is Stacy. Can I get your customer code?
Yes, 57104.
Thank you. And your password?
SIOUXFALLS.
And the courtroom number?
JC.
And then what is the case number?
It is, there's two of them, 217391 and 225171.
Thank you. And then what is your name?
Judge Eric Johnson.
Thank you. One moment while I get you a Lao interpreter.
Thank you.
Thank you for holding. I have your Lao interpreter on the line. You may begin.
Thank you. Hello?
Hello, sir. This is Sam, Lao interpreter. My ID consists with 4 letters. That is SIAM. How may I help you, sir?
Very good. You're going to be interpreting in a criminal courtroom for me, so the first thing I need to do is swear you in. If I could have you raise your right hand, please. And would you
Okay, Your Honor.
do you solemnly swear to fairly and justly interpret for Valet Chantalak from English to Laotian or Lao, and from Lao to English, so help you God?
I do, Your Honor.
Thank you. All right. So this is State of South Dakota versus Valet Chantalak.
อันนี้อยู่ที่ศาลอยู่ที่รัฐของดาโคตาในคดีของวันเลจันทลักษณ์
Mr. Chantalak, you are here on 2 criminal cases.
จันทลักษณ์เจ้ามาพวกก็มีการฟ้องเจ้าในคดีอาญา2 คดีนำกัน
In criminal file 21
Well, that looks like Mark Burgess on the left there. So maybe we're going to get to hear from him.
You are making your initial appearance.
Hopefully you
on
heard me
charges
over
including
above the
distribution
judge.
or possession with intent to distribute
Hang on, I'll just pause it there. So that's Mark on the left there.
a Schedule 1 or Schedule 2 controlled substance.
แล้วก็ที่เจ้าฟ้องเขาเนี่ยเป็นคดีอาญาก็เนื่องจากว่าเจ้ามีของที่เป็น
And that's Mark just walking out again.
ยาที่เป็นยาติดที่อยู่ในครอบครองและเพื่อหวังที่จะเอาไปขาย
That charge is a
แล้วการลงโทษเนี่ยอย่างสูงก็ประมาณ10 ปีหรือว่า$1,000 ค่าปรับ
That offense carries a mandatory minimum 1 year in the state penitentiary if convicted that cannot be suspended.
ถ้าเป็นคดีที่เขาจะรู้ว่าเราจะผิดพลาดแล้วก็เจ้าก็จะต้องอยู่ในห้องที่กักขังซึ่งบ่มีผู้ใดเข้าไปยุ่งเกี่ยวกับเจ้าได้ประมาณ1 ปี
In count 2, you are charged with possession of a controlled drug or substance in Schedules 1 or 2.
แล้วคดีที่2ว่าเจ้ามีสิ่งของเหล่านี้ซึ่งเป็นยาเสพติดนั่นอยู่ในครอบครองตัวของเจ้า
That is a Class 5 felony.
อันนี้เป็นเขาเรียกว่าคลาสหมายเลข5เป็นคดีอาญา
Punishable by up to 5 years in prison and or a $10,000 fine.
อันนี้คดีนี้ถ้าผิดพลาดแล้วถ้าฮู้ว่าเจ้าผิดแล้วก็เจ้าลงโทษสามารถไปได้ฮอดถึง5 ปีแล้วก็สามารถปรับไปประมาณ10,000 เหรียญ
These charges stem from an incident back in March of 2021.
อันนี้เป็นคดีที่อยู่ข้างหลังมาตั้งแต่เดือนวันที่2021
And they've been out on arrest warrant for some time now.
แล้วก็มีการที่พยายามที่จะติดซ่อนแสวงหาออกหมายจับเจ้าเป็นช่วงระยะพอสมควร
Then in criminal file 225171, you're making your initial appearance on 2 additional charges.
ตอนนี้เป็นคดีที่อยู่ในของศาลนี่25121ซึ่งมาฟังเรื่องราวที่เขาเจ้าฟ้องเจ้านี่2 คดีนำกัน
The first is another count of possession of a controlled drug or substance in Schedules 1 or 2.
แล้วก็คดีอันนี้ก็ที่เราจะมีของเสพติดนี่อัน1หรือทั้ง2
That is again a Class 5 felony.
อันนี้อีกอย่างหนึ่งก็เป็นคดีของคลาสหมายเลข5เป็นคดีอาญา
Punishable by up to 5 years in prison and or a $10,000 fine.
อันนี้ลงโทษได้สูงก็คือ5 ปีแล้วค่าปรับประมาณ 10,000 เหรียญ
And then possession or use of drug paraphernalia.
แล้วก็มีของยาเสพติดอยู่ในตัวหรือว่ามีสิ่งของที่คล้ายๆคลึงกับพวกนักยาเสพติดนั่นอยู่ในตัวเจ้า
That is a Class 2 misdemeanor.
อันนี้เป็นเขาเรียกว่าคลาสหมายเลข2เป็นคดีละหูโทษ
Punishable by up to 30 days in jail and or a $500 fine.
อันนี้ลงโทษอยู่ในเขาที่เจ็บประมาณ30 มื้อแล้วก็จะถูกhow much the fine your honor
The possible fine would be up to $500.
การถูกปรับจะประมาณ$500คดีละหูโทษนี่
I'm going to advise you of your constitutional and statutory rights.
เราก็จะแนะนำให้เจ้าฮู้ว่าเรามีสิทธิอันใดและเสรีภาพของเรามีอย่างใดแน่
And this would be true for the other folks who are present in the jail courtroom as well.
เราสำหรับทุกๆคนที่อยู่ในห้องศาลเราคือกัน
In this set of cases, Mr. Chantalak, you have the right to be represented by an attorney.
มิสเตอร์ชันตลักษณ์เราก็ฮู้ว่าเรามีสิทธิที่จะมีทนายความมาเป็นผู้สู้คดีให้เจ้า
And to have an attorney appointed for you if you cannot afford to hire one to represent you.
แต่ถ้าบ่มีเงินที่จะจ้างทนายความทางศาลก็จะแต่งตั้งทนายความมาช่วยเจ้า
You have the right to a speedy public trial in the county where the offense is alleged to have occurred.
เราก็มีสิทธิที่ว่าคดีเรื่องราวเนี่ยบ่แม่นยืดยาวไปแต่มีสิทธิที่จะต้องทำคดีของเราให้มันเสร็จอยู่ในเวลาที่สมควรนั้น
In front of a fair and impartial jury made up of 12 residents of this county.
ซึ่งจะมาฟังเรื่องราวของเราอาจจะเป็น12คนตุลาการต่อหน้า12คนมาฟังคดีของเรา
Members of the jury would have to listen to all of the evidence presented at trial.
เราทางตุลาการ12คนก็มาฟังเหตุผลเรื่องราวต่างๆของเราที่เขาเจ้าฟ้องนั้น
Then they would have to come to a unanimous verdict.
เราทุกคนก็ตกลงกันว่าเฮานี่ผิดแน่นอน12คนนั้น
Meaning all,
ว่าเราผิด
and that means that all 12 people would have to agree as to whether you are guilty or not guilty.
เราจัง12คนก็ต้องเห็นดีนำกันว่าเราจะผิดหรือบ่ผิด
At a trial, you would be presumed innocent unless and until the state could prove you guilty beyond a reasonable doubt.
แล้วสิทธิของเฮาก็คือเมื่อเวลาเราสู่คดีนี่ก่อนที่ยังจะฟังเรื่องราวก็ถือว่าเราก็ยังเป็นคนที่บ่ผิดกฎหมายเถือจนกว่าเราจะมีหลักฐานพอเพียงว่าเราผิด
That means that if you have a trial, the burden will never be on you to show that you're innocent.
แล้วก็บ่มีผู้ใดที่จะมาเบาขู่เข็นเฮาว่าเขาต้องฮู้ว่าก่อนที่ฟังเรื่องราวเราแล้วเราถือว่าเราเป็นคนที่ยังบ่ผิด
The burden would be on the state throughout the trial to prove with proof beyond reasonable doubt that you were guilty of the charges that you face.
แล้วก็ทางสเตทเนี่ยทางรัฐนี่ก็ต้องหาหลักฐานพอเพียงบอกให้ทางพวกเจ้าฮู้ว่าเรามีหลักฐานพอเพียงบ่ว่าที่เขาเจ้าฟ้องมาเนี่ยมันเป็นความผิดที่แท้จริง
At a trial, you have the right to confront and cross-examine the witnesses who testify against you.
ในระหว่างที่เราต่อสู้คดีนั้นเราก็มีสิทธิที่จะซักไซ้ไล่เลี้ยงไอ้พวกตำรวจบ่หรือพวกคนที่พยานหลักฐานที่เขามาฟ้องเรามีทนายความไปซักไซ้ไล่เลี้ยงช่วยแทนให้เฮา
That means you have to be allowed to be present in the courtroom to see and hear the evidence presented.
อันนี้หมายถึงว่าเราก็มีสิทธิที่อยู่ในห้องไปฟังเรื่องราวทั้งหมดที่มันเกิดเหตุว่าผู้ใดบ่อันใดแน่
To see and hear the witnesses testify and to question the witnesses in open court in front of the judge and or the jury.
เราก็มาฟังมาเห็นในระหว่างที่ตุลาการ12คนฟังเราทางผู้พิพากษาฟังแล้วก็พวกพยานหลักฐานฟังเราจะต้องรู้ต้องเห็นทุกคนในระหว่างที่เขาเจ้าเฮ็ดในคดีของเจ้านี้
You also have the right to compulsory process.
เราก็มีสิทธิที่จะให้ฟังในการที่คดีของเขานี่ให้มันเป็นไปตามแบบที่เวลาที่กำหนดให้นั้น
Which really means that if you have your own witnesses that you want to call to testify for you, you have the right to do that.
แล้วอย่างหนึ่งถ้าเราเห็นว่าทุกอย่างบ่ถูกต้องแล้วเราก็อยากจะเว้าออกมาแล้วก็มาเป็นพยานให้ตัวเราเองเราก็มีสิทธิเว้าได้คือกัน
And if you are worried that your witnesses will not come to court voluntarily,
แต่เรามีความกังวลกระวายว่าคนที่จะเป็นพยานให้เฮานี่เพิ่นบ่อยากมาแต่ว่าศาลก็จะออกคำสั่งให้เพิ่นมาช่วยเจ้า
you have the right to serve them with a subpoena.
เราก็มีสิทธิที่จะศาลจะออกคำสั่งให้เพิ่นมา
which is an order from the court forcing them to come testify even if they don't want to.
แล้วศาลเนี่ยจะออกคำสั่งให้เพิ่นเป็นกฎหมายถ้าเพิ่นบ่มาบ่ได้แล้วเพิ่นก็จะมาเป็นพยานให้เฮาเมื่อเวลาศาลต้องการให้เพิ่นมาเป็นพยานให้เฮาและตัวเจ้าเองต้องการให้เพิ่นมาเป็นพยานให้เจ้า
You also have the right against self-incrimination, which means the right to remain silent.
แล้วอีกอย่างหนึ่งเราก็มีกฎหมายของเขาคุ้มกันก็คือเราก็บ่อยากเว้าหยังก็ได้เรานั่งอยู่เงียบๆก็ได้ถ้าเราเว้าหยังไปมันอาจจะมีการฟ้องตัวเฮาเอง
While your case is pending, you do not have to say anything or admit anything about the facts or evidence in the case.
ในระหว่างที่เรื่องราวคดีที่เขาเจ้าเขาฟ้องร้องเฮานี่เราบ่ต้องจำเป็นต้องเว้าหยังออกมาหรือบ่ต้องให้ผู้ใดมาตะขู่มาคอกเขาตอนนี้เจ้าก็ยังเป็นคนที่เหมือนก็ยังบ่มีความผิดอยู่จนกว่าเพิ่นจะฮู้หลักฐานพอเพียงว่าเราผิดอย่างแท้จริง
If you have a trial, you do not have to testify, and no one can force you to testify.
ถ้าเราขึ้นต่อสู้คดีแล้วเจ้าบ่จำเป็นต้องเว้าบ่ลุกขึ้นมาเว้าก็ได้บ่มีผู้ใดบังคับให้เราเว้าก็ได้
And if you choose to remain silent while the case is pending or at trial, the fact you remain silent cannot be used or considered as evidence against you.
ระหว่างที่เราอยู่เราบ่เว้ามาฟังเรื่องราวซื่อๆให้พวกเจ้าเว้าเองแล้วที่เพิ่นเว้าออกมาหรือจังไดก็บ่แม่นว่าหมอนี่ผิดแล้วเพราะว่าเพิ่นบ่เว้าหยังออกมาบ่แม่นเป็นจังซั่นให้เพิ่นเว้าของเพิ่นเอง
Because you are charged with felony offenses, you also have the right to a preliminary hearing.
เมื่อเขาเจ้าฟ้องเฮาเกี่ยวกับเรื่องคดีอาญานี่เราก็มีสิทธิ์ที่ให้เพิ่นมาฟังเขาเรียกว่า preliminary มาฟังเรื่องราวอีกเทื่อนึงหลังจากที่พวกเขาเจ้าเว้ากัน
That is a hearing held in front of a judge before your case can be scheduled for trial.
อันนี้หมายถึงว่าเรื่องของเฮานี่มาฟังระหว่างผู้ที่ฟ้องแล้วก็ทางฝ่ายตัวเจ้าเองแล้วก็ต่อหน้าผู้พิพากษา
At that hearing, it would be the state's burden to prove that they have what's called probable cause.
เรามาฟังเรื่องราวอันนี้ทางผู้พิพากษาก็ฟังโอเคนี่แล้วมันพอเพียงบ่ที่เป็นหลักฐานที่จะเอาเรื่องเพิ่นได้
Which means a crime has probably been committed and you are probably the person that committed it.
เรามาผู้พิพากษามาฟังเรียบร้อยแล้วเอาละไอ้ที่เจ้าเฮ็ดนี่มันผิดกฎหมายแน่แล้วก็มาหรือบ่ผิดจังใดก็มาฟังในขั้นตอนก่อนที่จะขึ้นต่อสู้คดีนั้น
If the judge finds that probable cause exists, your case is bound over for trial.
ทางผู้พิพากษามามองเห็นเรียบร้อยแล้วโอเคมันพอเพียงแล้วเรื่องที่จะต้องขึ้นสู่คดีกันทางผู้พิพากษาก็อนุญาตให้เราไปต่อสู้คดีกัน
If the prosecutor cannot meet that burden, then the felony charge will be dismissed.
ทางผู้พิพากษาเพิ่นบ่มีหลักฐานพอเพียงแล้วท่านผู้พิพากษามาฟังเรียบร้อยแล้วมันบ่มีหลักฐานพอเพียงแล้วคดีของเจ้าก็ยุติไปเลิกล่มไปบ่มีคดีต่อ
Do you understand that you have those rights, Mr. Chantharath?
มิสเตอร์ชันชราเจ้าเข้าใจบ่ในสิทธิเสรีภาพของเฮาที่ท่านผู้พิพากษาได้อธิบายเจ้าฟังมื้อนี้เข้าใจ Understand your honor.
And do you understand the charges against you and the maximum penalties, Mr. Chanthalath?
มิสเตอร์ชันชราเข้าใจบ่ท่านผู้พิพากษาได้อธิบายให้เจ้าฟังในการที่เจ้าฟ้องร้องเราแล้วคดีที่เขาเจ้าจะลงโทษเราในถึงขนาดใดเข้าใจ
You might have to answer a little louder.
Yes. Yeah, I do understand.
I have your application for an attorney.
เอาล่ะเรามีเกียร์กระดาษเอกสารให้เจ้าเพื่อเจ้าจะได้ไปติดต่อทางทนายความ
Was the information you wrote down true to the best of your knowledge and ability?
นี่เป็นความจริงตามที่เจ้าฮู้นี่แม่นบ่แม่นแล้ว Yeah, that is correct.
Are you working right now?
ปัจจุบันนี้เจ้าเฮ็ดเวียกเฮ็ดการบ่ No.
Would you guess that your income over the last year was less than $50,000?
รายได้ของเจ้าเมื่อปีที่แล้วนี่มันน้อยกว่า 50,000 เหรียญแม่นบ่ Yes.
And that's your signature on the bottom?
อันนี้เป็นลายเซ็นของเจ้าแม่นก็อยู่ข้างลุ่มนี่ Yes.
I find that you qualify and appoint the Public Defender's Office to represent you.
Your Honor,
เอา
it's
ละ
gonna need,
เราก็เหมาะผมพอเพียงที่จะแต่งตั้งให้ Public Defender และทนายความหลวงมาเป็นทนายความช่วยต่อสู้คดีให้เจ้า
Actually, apparently, Mr. Chanthalak, there is a conflict with the Public Defender's Office.
โอ้เดี๋ยวฟังก่อนเพราะว่ามันมีอย่างคัดกันระหว่างกับ Public Defender Mr. Chantalak
So I'm going to appoint a private attorney, Melissa Fixstall, to represent you.
เอาล่ะเราจะแต่งตั้งทนายความข้างนอกทั่วไปบ่แม่นทนายความของหลวงทนายความข้างนอก Mr. Siklo ก็ยังเป็นทนายความเป็นผู้มาช่วยคดีของเจ้า
On her behalf, would you accept the appointment and waive reading and advising?
yes, Your Honor.
มันเรายินดีที่จะรอมรับต่อแม่ละท่านผู้พิพากษา
What is the state's position on bond?
Judge,
บานเท่าใดก็
I'm requesting $5,000 cash only on each file.
ท่านบอกท่านผู้พิพากษาก็บอกให้เราฮู้ว่า 5,000 เป็นเงินสดเท่านั้นที่จะมาประกัน
As well as no drugs,
แต่ละคดี
as well as a no drugs condition and the 24/7 program.
บ่มียาเสพติดแล้วก็เบิ่งแยงติดตามเพิ่นไปมาสาย24ชั่วโมง
In the 2021 file, it indicates a controlled buy by law enforcement.
แล้วก็ซาว1ซาวประสานงานเรียกกับพวกทางเจ้าหน้าที่ตำรวจ
And in the latest allegation, law enforcement located a plastic baggie with a substance believed to be meth inside his pants pocket.
แล้วก็ตอนหลังเนี่ยเรามาค้นพบว่าเรามียาเสพติดเขาเรียกว่าอาจจะเป็นยาบ้ายาเม็ดนี่อยู่ในถุงข้างในของเพิ่น
In addition to these pending cases, he has a pending receiving stolen vehicle and possession of controlled substance.
แล้วนอกจากมีคดีนี้แล้วเพิ่นก็มีคดีอันเก่าๆอยู่ว่าไปลักลอบขโมยเราไปเกี่ยวกับเรื่องยาเสพติดนำ
where he failed to appear at the initial appearance in Moody County in June of 2021.
แล้วก็ในศาลบอกให้เพิ่นไปมอบตัวอยู่ที่ศาลเพิ่นที่ย้อนหลังไปเดือน6วันที่2 2021
In addition, there are 2 other pending PCS cases.
แล้วนอกจากนี้แล้วก็มีคดีของ PCS คดีทั้ง2อัน
where loss of contact warrants were issued in September of 2021.
แล้วที่ทางเจ้าหน้าที่ตำรวจก็ได้ประสานเรียกติดต่อเพิ่นเดือน September วันที่21
Thank you.
ขอบใจละท่านผู้พิพากษา
I went in and looked at Mr. Chantharat's old case, and Jeff Beck was actually appointed instead of a different attorney, so I'm going to reappoint Mr. Beck instead of Ms. Fixstall. But
เมื่อเราได้ฟังเรื่องราวนี้เราจะได้แต่งตั้งMr. Beck แทนที่ Mr. Edro
Mr. Van Buren, anything on bond?
Your Honor, we would request that the court consider a lower cash or surety bond.
ขอให้ท่านผู้พิพากษาพิจารณาในการลดไปในการที่จะบอนหรือว่าไปเอาตัวออก
I note that this distribution case does stem from the alleged sale of $150 worth of methamphetamine.
ในการที่ฟ้องคดีนี้ก็คือเป็นยาบ้าที่ต่ำกว่า$160ยาเม็ดที่นั่น
V.U.K.T did provide an address and a phone number, so I anticipate him being able to stay in contact with his attorney if he were to post bond.
เราเพิ่นเอาได้ที่อยู่ที่ทางโทรศัพท์ต่างๆให้เราจะได้ติดต่อทางทนายความเวลาเพิ่นจะติดต่อเพิ่น
He indicates here that he would be willing to do the 24/7 program.
แล้วเพิ่นก็ได้บอกให้เฮาฮู้ว่าเพิ่นอยากจะเข้าไปในโปรแกรม7 มื้อ24ชั่วโมง7 มื้อ
I guess we were limited in how much information we could get from him due to the language barrier, but we would ask that all that be taken into consideration and would request, again, a lower cash or surety bond.
โดยนี้เราจะหาว่าเรื่องประสงค์ภาษาของบุคคลเข้าใจทัดใดก็เลยร้องขอให้ทางผู้พิพากษาลดไก่บานหรือว่าที่จะประกันตัวออกให้ลดน้อยลง
I've reviewed Mr. Chanfelok's record. I see the prior offenses referenced by the attorneys.
พอได้ตรวจสอบต่างๆที่คดีอันเมื่อก่อนแล้วก็พิจารณาทางผู้พิพากษาที่ได้บอกทางทนายความเพิ่นได้บอกให้เฮานั้น
I believe, with the exception of the cases on today's calendar, each of the felony cases has at least one and some multiple missed court dates.
แล้วก็มาฟังเรื่องราวแล้วก็คดีที่เก่าๆมาเนี่ยก็มีมากกว่า1หรือ2เทื่อที่เขาบอกให้มาศาลแต่เจ้าบ่ได้มาศาล
These would be the fourth and fifth pending cases involving controlled substance and one now involving distribution.
เรานี่เป็น4ถึง5เทื่อแล้วที่เกี่ยวกับเรื่องการใช้ยาเสพติดแล้วนึงเป็นคดีต่อไปนี่เป็นคดีเกี่ยวกับเรื่องการที่จะไปทำการค้าขายเกี่ยวกับเรื่องยาเสพติด
The drug distribution case is older, but drug dealing is inherently dangerous to the community.
การเอายาไปขายแล้วก็มันเป็นคดีเก่าแล้วแต่ว่าเป็นคดีที่หายแฮงสำหรับcommunity นี่หรือว่าแถวรอบเมืองนี่
Given the history of failure to appear and the finding of danger to the community, I'm setting the bond on 217391 as requested at $5,000 cash.
ส่วนโดยเหตุนี้การที่จะมาประกันตัวนี่ก็ยังคดีที่21731ที่จะมาประกันตัวก็ต้องใส่เงินประมาณ$5,000
Bond conditions would be that you be on good behavior, stay in contact with your attorney, and attend all of your court appearances.
แต่มันขึ้นอยู่กับการติดต่อทนายความหรือว่าติดต่อทางศาลเมื่อทางศาลบอกให้มาก็ต้องมา
Also, no drugs without a valid prescription.
แล้วก็มียาบ่ต้องมียาเสพติดบ่ต้องมีอย่างในระหว่างที่ประกันตัวออกไปนั่นหรือพวกเหล้ายาบ่มี
On the new case, 225171, given that these are the fourth and fifth cases with several failed to appears, I'm setting that bond at $2,500 cash or surety.
แล้วคดี22151นี่นี่มันก็เกิดขึ้นหลายๆเทื่อหลายเรื่องนี้มา4-5เทื่อแล้วนี่เราประกันตัวเป็นบานก็ประมาณ$2,500
Good behavior, stay in contact with your attorney, attend all of your court appearances.
So FTP has returned.
คือให้คำมั่นสัญญาว่าติดต่อทนายความประจำแล้วเวลาเพิ่นบอกให้ขึ้นศาลก็ต้องมาขึ้นศาล
No drugs without a valid prescription.
Testing.
ห้ามกินยาเฉพาะยาที่ในหมอสั่งให้เท่านั้นยาที่บ่ได้สั่งหมอก็ห้ามกิน
Typically, I might order 24/7, but given that we don't have an interpreter here in person, I think that's a challenge to explain very well, and so I'm not going to order it today.
ตามปกติเราจะออกคำสั่งให้เจ้า
They don't have an interpreter, but it appears they have possibly a psych person or something there to support Mark.
Your not guilty pleas and set 15-day preliminary hearings on each file.
แล้วก็ตอนนี้ก็ยังบ่รับเทื่อแล้วก็มานัดกันไปอีกเทื่อนึง15มื้อทั้ง2คดีนั่น
All right. Thank you.
ขอบคุณใจหลาย
And then on the good face case, can I see the file?
ถ้าเราเบิ่งในไฟล์ของเจ้า
All right. Sir, thank you for your assistance. I think our case is concluded. Appreciate it.
Thank you, Your Honor, for your service.
Thank you.
Yes, sir. Bye-bye.
I have found probable cause to detain Mr. Goodface. According to the bond schedule, he can be passed until tomorrow.
Looks like I timed my introduction very well. I might be back for the main event.
If I may approach with the order for belongings.
Yes.
Mark doesn't seem very want to get his face on the camera. All right, here we go by the looks of it.
All right. right, so this is on the 3 o'clock calendar, State of South Dakota versus Mark Burgess, here with Ms. Smith. It is criminal file 223904. Mr. Burgess, you are charged in an 8-count complaint. Count 1 alleges 1 count of stalking, which is a class 1 misdemeanor, punishable by up to 1 year in jail and or a $2,000 fine. Counts 2 through 7 inclusive, so that would be 6 counts of permitting, threatening, or harassing telephone calls. Each of those counts is a class 1 misdemeanor. Each is punishable by up to 1 year in jail and or a $2,000 fine. And then finally, count 8 alleges a terrorist threat. That is a class 5 felony, punishable by up to 5 years in prison and or a $10,000 fine. Do you understand that you face those charges and the maximum penalties, Mr. Burgess?
Yes.
And Ms. Smith, my understanding is that Judge Power appointed the Public Defender's Office on all of Mr. Burgess's pending cases today. Is that your understanding?
Yes.
Okay. If for any reason you haven't been, I would appoint on this case as well. State have a position on bond?
Yes, Judge. State's asking that the arrest warrant of $50,000 cash only be converted to bond. I'm asking for no contact with the hotel located at 1500 North Kiwanis Avenue here in Sioux Falls, Minnehaha County. The allegations here is that the alleged victim was the manager of a hotel. Mr. Burgess had called in, had threatened her, had told her that he was going to, quote, fuck your shit up royally with a gun, told officers to kill themselves with their service weapons after they made contact with him. He made over 30 calls to the hotel and to the victim, and at one point told the victim that he would kill the victim and her children with a gun, and that he would come to the hotel and beat her with a bat, and then he would burn down the hotel. He continued to call her multiple times and continued to threaten her. He's got numerous pending cases, including felony VPO and stalking, violation of protection order, history, terroristic threat, reduced to simple assault, resisting arrest, and obstruction convictions, eluding, obstructing, and trespass convictions as well. That's all I have, Judge. Thank you.
Thank you. Go ahead, Ms. Smith.
Thank you. Your Honor, we're asking the court to set the bond in this case at a personal recognizance bond. This essentially started out as a civil dispute for charges that were made to his bank card without authorization and escalated into what we have here now. The state's rendition of the facts are basically one-sided, with only making comments to what was his statements without any comments referencing what was made by the other side, intentionally escalating the situation both by law enforcement, which were also present when some of these comments were made. There's no actual physical violence here. There's no actual indication that he actually went any further as far as acting out on any of the statements that were made. It's my understanding he's already posted a $5,000 bond on another matter, so he doesn't have any reason that he would leave the area or not show up for any of his court appearances. So based on that, Your Honor, we're asking the court to set bond at a personal recognizance bond with just simple conditions that he made contact with our office. And he, of course, he's willing to abide by the no contact.
I've read through the arrest affidavit, the arrest amount on the arrest warrant was set by a circuit court judge, so I've reviewed that. The PSA views Mr. Burgess as a high risk to miscourt and to reoffend. He does have some history of threatening phone calls, and that sort of offense is out on bail, looks like, on stalking charges prior to this. Does have a violation of protection order that is pending as well. Allegations in the affidavit are certainly concerning. There are not, however, allegations of actual violence, so I do take that into consideration. So while I do think that a substantial bond is appropriate, I'm going to set it at half of what the state's asking for. $25,000 cash, good behavior, stay in contact with your attorney, attend all of your court appearances, no contact with Kimberly Teets or 1500 North Kiwanis Avenue here in Sioux Falls. That means no contact in person, no telephone calls, no voicemails, emails, text messages, third-party contact, or social media contact, and no contact within 500 feet of that address. We'll enter a not guilty plea and set this matter then for a 15-day preliminary hearing. All right, thank you. And then could I have Mr. Grunewald come up? Was counsel appointed on this yesterday?
I believe he did not fill out an app.
Were or were not?
No.
Okay.
He didn't fill out an app yesterday. I don't know if he
Okay.
wants to apply today.
Well, there we have it.
File 22-5154,
Bond
Mr. Grunewald.
at 25,000. So I assume he's got to find 2,500 to put down. Be interesting if we see him out of jail.
So, Mr. Grunewald, you are charged with
Thanks for watching. I'm going to stop there.
Schedules 1 or 2, which is a class
So it
5
renders,
felony.
and
I'm doing it here?
Hold on.
we'll hopefully bring you some
Punishable by
more
up to
of
5
Mark
years in prison and or a
when he
$10,000
appears, if he
fine.
appears from
You're
jail.
also
Obviously,
charged
this
with
is
disorderly
quite a good
conduct
place
and
for a
use or
stream.
possession of drug paraphernalia.
Right.
Each of those
Catch
are
you
class
later.
2 misdemeanor.
Thanks.
Each is punishable by up to 30 days
Sorry I
in jail
wasn't in
and or a
chat for a lot.
$500 fine. You understand those
But
charges and the maximum
It
penalties?
was worth
Mr.
hanging
Grunewald?
around for us to see that. So catch you all later.